Hello, my name is Melissa Worth and I am a solicitor helping businesses and individuals to resolve their commercial disputes. Each week, as part of my weekly law review, I take a look at a recent court decision. This week I am looking at the case of Travel Counsellors Ltd and Trailfinders Ltd, which was handed down in the Court of Appeal on the 19th of January 2021. The case was concerned with whether the defendants were liable for disclosing confidential information from their previous employer Trailfinders to their new employer Travel Counsellors, and also whether Travel Counsellors was also liable for accepting the confidential information. The first instance decision, or the decision in the High Court, was given on the 12th of March 2020. The High Court heard that Mr L and Mr B worked for the claimant, Trailfinders, a travel agency. Both Mr L and Mr B moved to work to the defendant, Travel Counsellors Ltd, and Mr L and Mr B took confidential information belonging to Trailfinders to Travel Counsellors. The information consisted of customer information which was valuable and confidential and had been taken from Trailfinders' electronic systems. Mr B had collated the information over a 6-month period, and Mr L had copied information on his last day before leaving the business. At the trial in the High Court, the judge was asked to determine, first, whether the information was confidential, secondly, whether Mr L and Mr B had breached equitable and contractual duties owed to Trailfinders by disclosing the information, and thirdly, whether Travel Counsellors was liable for Mr B's and Mr L's actions because the two had misused the information in the course of their employment at that company. In other words, was Travel Counsellors vicariously liable for Mr B's and Mr L's actions? The court found that yes, the information was confidential, and yes, the two employees had breached their contractual and equitable duties, and yes, Travel Counsellors was vicariously liable. It was this decision which Travel Counsellors, but not Mr L or Mr B, appealed to the Court of Appeal. There were 3 grounds of appeal, and I deal with each in turn. First, Travel Counsellors argued that the judge applied the wrong test when holding out that Travel Counsellors owed an obligation of confidence relating to the confidential information received from Mr L and Mr B. This was rejected by the Court of Appeal. The court restated the relevant test, and the judge said, "In my judgment, if the circumstances are such as to bring it to the notice of a reasonable person in the position of a recipient, but the information or some of it may be confidential to another, then the reasonable person's response may be to make inquiries. Whether that person would make inquiries, and if so, what inquiries, is inevitably context and fact dependent. If the reasonable person would make inquiries, but the recipient abstained from doing so, then the obligation of confidentiality will arise." The second ground of appeal was that the trial judge's approach to the question of what Travel Counsellors ought to have understood about the information was wrong. However, this was a criticism of the trial judge's findings of fact. The Court of Appeal did not accept that the judge had made the wrong finding of facts at first instance. The third ground of appeal was that the judge was wrong to hold that Travel Counsellors Ltd was liable for breach of confidence, even though it had found that Travel Counsellors Ltd had misused the confidential information. Now, this third ground was actually abandoned during the appeal hearing. This was partly because Travel Counsellors admitted that information had been stored on its systems and had been used to send marketing emails. So the appeal was dismissed. This case helpfully clarified the test, which the court will use when asked to determine whether a third party will be liable for receiving confidential information. As I stated, or rather as the judge stated, the question is whether the reasonable person receiving such information would make inquiries. Whether the reasonable person would make inquiries and the extent of those inquiries is context and fact dependent. In my view, this is probably good news for lawyers representing claimants. I say this because cases which rely heavily on a particular finding of fact being made tend to carry more risk for litigants, and as such, a defendant may be more likely to settle a case because it may wish to buy off the risk of a finding of fact being made against them at trial. The key takeaway point for businesses is to exercise caution when dealing with potentially confidential information when recruiting employees that have worked for a competitor. If the employees have breached their duties of confidentiality to its former employer, then the new employer could be found liable too. If you have any queries about the points raised in this case, please do get in touch. I'll be delighted to hear from you. Many thanks.